Good day to Madam. My name is Lim Wei Hong. Today, my team members and I will be conducting the video presentation project for Contract Law 2. Our team consists of 5 members, which includes me, Lim Wei Hong, Tan Cheng Hui, Ronald Ong, Harini Saravanan, and Ruben Tiaga. To start off our presentation, I'll be going through the case facts and timeline in brief for the presentation question. In January 2024, Aman contracted to construct a 3-story commercial complex for Emerald for Rm 12 million under a 4-stage payment framework. By August 2024, Aman achieved successful progress by completing 75% of the works and receiving Rm 9 million across 3 certified stage payments. However, due to rising material costs in September, Emerald verbally granted a 3-month extension and promised an additional Rm 500,000. Despite this arrangement, Aman faced financial insolvency between November and January 2025, slowing progress until work ceased entirely and causing them to ignore Emerald's formal 14-day notice to resume operations. The timeline concludes in February 2025 when severe flooding destroyed the structure and a 2-year government stop work order was issued, prompting Emerald to formally terminate the contract on February 10. Next, I'll pass the floor to my group member Harini to discuss about the first issue in this question.
Good day, madam. My name is Harini Saravanan and I will discuss the first issue, which is whether the September 2024 arrangement between Emerald Development and Aman Build validly varied the original construction contract. Under the original contract, Aman was required to complete the project by 31st December 2024. In September 2024, Aman requested a 3-month extension and also an additional payment of 1 million ringgit due to the increased construction cost. Emerald agreed to extend the completion date to 31st March 2025 and also agreed to pay an additional sum of 500,000 ringgit provided that Aman maintained reasonable progress. The relevant provisions are Section 63 and Section 64 of the Contracts Act 1950. Section 63 states that it allows party to alter a contract by mutual agreement, while Section 64 states that it allows a promisee to extend the time for performance or waive a contractual right without requiring fresh consideration. The main case laws for this question is Kirpa Singh against Baryam Singh, Polygram Records against The Search, and also Mawar Awal against Kepong Management. The applications for these cases is, in the case of Kirpa Singh against Baryam Singh, the court held that Section 64 is a promisee may extend the time for performance without a fresh consideration. Applying this case, Emerald's agreement to extend the completion date from 31st December 2024 to 31st March 2025 is likely valid even though Aman provided no fresh consideration. Second, in the case of Polygram Records against The Search, the court recognized that parties may alter certain terms of a contract while allowing original contract to continue. Here, Emerald and Aman agreed to change the completion date and payment agreement. Therefore, the September agreement is likely a valid alteration under Section 63 of the Contracts Act 1950. Third, in the case of Mawar Awal against Kepong Management, the court held that where a certain obligations are modified, the original contract remains in force. Similarly, the January 2024 contract continued to exist, but with amended compilation and a new payment term. However, Emerald may argue that Aman is not entitled to the additional Rm 500,000 because the payment was conditional upon maintaining a reasonable progress and Aman later slowed down and stopped the work. In conclusion, the September 2024 arrangement is likely a valid contractual variation under Section 63 and Section 64 of the Contracts Act 1950. Under Section 63, the parties mutually agreed to alter the completion date and payment terms. While under Section 64, Emerald validly extended the time for performance without the need for the fresh consideration. Therefore, the absence of the formal supplementary agreement does not invalidate the variation. The original contract remained in force but operated to the according revised terms. Nevertheless, Aman may have difficulty in claiming the additional 500,000 ringgit because the condition maintaining reasonable progress appears not to have been fulfilled. That's all from my part. Thank you.
Hello everyone, now I will present the second part of our legal analysis focusing on Iman's decision to stop the construction work. Let's quickly look at the facts. Between November 2024 and January 2025, Iman progress on the complex significantly slowed down and eventually stopped completely. On 15th of January, Emirate issued a 14-day notice demanding Iman to resume work, but Iman refused. Iman's excuse was financial inability due to rising material costs, and they blamed Emirate for only giving them an extra 500k instead of the 1 million ringgit they had originally asked for. So, the core legal question we must answer is, does running out of money give a contractor a valid legal defense to stop working, or does this act constitute a fundamental breach of contract? To find the answer, we first look at Section 40 of the Contract Act. The section states that if a party to a contract completely refuses to perform their promise in its entirety, the innocent party has the right to put an end to the contract. Applying this to our case, Iman didn't just experience a delay. They completely abandoned the project site. While Emirate gave them a formal 14-day notice to resume operation, Iman clearly refused. This total abandonment amounts to a complete refusal to perform their contractual promise. Because of this, Iman violated Section 40, which legally justified Emirate rights to terminate the agreement. Next, we need to examine the project timeline under Section 56, subsection 1 of the Contract Act. This section provides that if time is of the essence in a contract and a party fails to perform by the specific deadline, the contract becomes voidable at the option of the innocent party. In our scenario, the original contract expressly states that time was of the essence. When Emirate agreed to extend the deadline to March 2025, it was strictly conditional on Iman maintaining reasonable progress. By completely downing their tube on January, Iman clearly failed to maintain this progress, breaching the strict timeline. Therefore, under Section 56 of subsection 1, Emirate was legally entitled to treat the contract as broken. Finally, let's address Iman's main defense, that they simply couldn't afford to build anymore. Under Malaysian contract law, there is a firm general rule. Commercial hardship or lack of fund is never a valid excuse to abandon a contract. This is strongly supported by two landmark cases. In the Federal Court of Pacific Forest Industry, the court ruled that a contract does not become legally impossible to perform simply because a party has no money to pay their debts. Furthermore, in the Court of Appeal case of Sentul Raya, the court ruled that an economic crisis merely makes a contract more onerous and expensive to perform, but it does not discharge the contract. To conclude my part, Iman's financial distress is purely a commercial business risk. It is completely invalid as a legal defense. By stopping the construction in January 2025, Iman committed a fundamental breach of contract, giving Emirates the absolute right to terminate the agreement. Thank you. Now I will pass the presentation to the next member.
Greetings, Miss. I'm Ruben. I kept my slides brief, so please pay attention to the presentation, as I don't have much time to explain everything. I'll get straight into it. Okay, so first, the issue of the case. It's whether Aman may rely on the doctrine of frustration to discharge the contract after the occurrence of the flooding and the government prohibition. despite his prior breach of contract. The statutory provision is section 57 sub 2. Okay, 57 sub 2 is basically talking that like the contract becomes void when the supervening event occurs and the act becomes impossible or unlawful. So the supervening event has to happen after the contract is made. Okay, next slide. Next is the test for frustration. I'm going to use the radically different test. So you can see in the Davies case, I can't explain the whole case, but the principles is the frustration only occurs where a supervening event makes the contractual obligation radically different from what the parties originally agreed. And a contract is not frustrated merely because performance becomes more difficult, expensive, or takes longer than expected. Okay, next slide. Force majeure clauses. I don't have to go much into that. It's basically there already. But yeah, the court will look into the terms of the clause first before applying section 57. So, okay. And finally is doctrine of the self-induced frustration. So, okay, based on the case of the maritime, national fish and ocean trawlers, it shows that a party cannot rely on doctrine of frustration if the supervening event occurs by their own choice, fault or neglect. So it must happen without the default of either party. Okay, and okay, now I want to come to the application, which is the most important part, miss. Okay, application for section 57 sub 2. Section 57 sub 2 provides that a contract becomes void when performance becomes impossible or unlawful due to an event which the promisor could not prevent. In this case, there's two supervening events, which is the severe flooding on 5th February, which destroyed substantial portions of the completed structure, and the government prohibition for 2 years. They don't allow any building for the safety. So Aman can argue that the contract was frustrated under section 57 sub 2. Next, the application of the radically different test. So you can see the two cases, Davies Contractors and Rumley. Frustration arises when the supervening event makes the performance radically different from what was originally agreed. So in this case, Aman was required to complete remaining 25% of the commercial complex by the extended date, which is 31st March. However, the flood severely damaged partially completed structure and construction was legally prohibited for 2 years. As a result, obligation was no longer to finish the remaining works, as it would require reconstruction after a lengthy suspension. This is very different from the original contractual obligation. Therefore, flooding and prohibition satisfy the radically different test. Next is the effect of the force majeure. The flooding constitutes as an act of God, while the prohibition is a government intervention. So the parties already allocated the risk of such events in the clause. So Aman may argue that the clause excuses liability for non-performance caused by the events. However, clause only protects the party whose failure to perform was caused by the force majeure itself. And finally, the application of the self-induced frustration. Okay, under the maritime case, frustration cannot be relied upon where the alleged frustrating event occurs by the party's own default. So, okay, before the flood occurred, Aman had significantly slowed progress between November 2024 and January 2025. And then construction work ceased entirely. Emerald issued a notice on 15 January requiring Aman to resume work in 14 days. Aman admitted that he was financially unstable to continue the project. Therefore, Aman's inability to perform existed before the flooding and government order. These supervening events did not cause Aman to stop work because he already stopped before this. Okay, so to conclude, although the flooding and government prohibition order were extraordinary events capable of frustrating the contract under section 57 sub 2, it doesn't matter because Aman already committed a serious breach before it happened. So applying maritime, national fish and ocean trawlers, frustration must occur without the default of either party, and a party cannot rely on self-induced frustration. Furthermore, with the force majeure clauses, it does not protect Aman because he already breached the contract earlier. Therefore, contract was more likely terminated due to Aman's prior breach rather than discharged by frustration. And Emerald has a stronger claim for damages against Aman. Thank you.
Okay. Hi everyone, I'm Cheng Hui and today I will talk about the remedies available to Emirate Development Sdn Bhd after Aman built Sdn Bhd breached the contract. So the main issue here is whether Emirate can claim damage for the replacement contractor loss, delay loss, and also the loss of rental income. So first, under Section 74 of Contract Act, when there is a breach of contract, the innocent party can claim compensation for loss that normally come from the breach or loss that both parties could reasonably expect when the contract was made. But remote or indirect loss cannot be claimed. In other meanings, damage are meant to put Emirate back in the position if the contract was properly completed. So this can be seen in the case of Hartley versus Baxendale. This case established that the principle that damage can be claimed if the loss happened naturally from the breach or if it was something both parties could have expected. If it is too far or unexpected, then it cannot be claimed. In another case of Beechon Rubber Factory versus Lô Samui, this case says that the damage are basically compensatory in nature, meaning the goal is to compensate actual loss and put the innocent party back to the original position. So the loss must be real and proven. Okay, now we're applying to our case. Emirate can claim the replacement contractor cost because Aman stopped work and didn't finish the project. So Emirate had to hire someone else to complete it, and that the extra costs come directly from the breach. Then, for delayed loss, the project was supposed to be finished within a timeline. But because of Aman's stop work, everything got delayed. So this kind of loss is also recoverable if it can be proven. So the last for rental loss. Since this is a commercial building, it is quite normal to expect rental income after completion. So if the delay caused Emirate to lose rental income, it may be claimed, but Emirate shows proper evidence for that amount. So in conclusion, Emirate is entitled to claim damage under Section 74. The replacement cost and delay loss are quite strong claim, and rental loss is possible but depends on proof and foreseeability. Thank you, and I will pass the floor to the next member.
Good day to Madam. My name is Lim Wei Hong. Moving forward with our group's analysis, my segment focuses entirely on evaluating the legal position and potential remedies available to the Aman-built Sdn Bhd. The core legal issue I'll be addressing today is whether Aman is legally entitled to retain the Rm 9 million paid to him and further claim compensation for work completed prior to the supervening events. Next, I'll be discussing about the law and authorities relevant to my issue. First, regarding the retention of past payments, under Section 66 of the Contracts Act 1950, which embodies the principle of restitution by dictating the mutual restorative of advantages when a contract is discovered to be or becomes void. We must read this statutory provision in light of the landmark Federal Court decision in the case of Lim Swee Choo against Ong Koh Ho 2025, which establishes the partial performance bar principle and clarifies that if a party has carried out partial performance, a claim of restitution based on a total failure of consideration is legally barred. thereby separating the law of breach from restitution. Second, to evaluate Arman's forward-looking claims for extra work, we look to the equitable concept of quantum merit, which is governed by the principle of reasonable remuneration, allowing party to recover money under the formula of as much as he has earned. Alongside the statutory framework of Section 71 of the Contracts Act 1950, which outlines the principle of obligation for non-gratuitous gratuitous acts, requiring a party to compensate another if they enjoy the structural benefits of a lawful non-gratuitous act. However, any claim for partial performance must clear three strict judicial requirements established by the common law. First is the entire contracts principle under the case of Carter against Powell (1795), which dictates that performance must be precise and 100% complete before a party can claim the agreed payment. Then the substantial performance exception principle under the case of K.P. Kunchi Raman against Goldboro Sdn Bhd 1978, which allows a contractor to sue for the contract sum minus defects only if the project is near completion and substantially performed. And finally, the voluntary acceptance principle under the case of Sumter against Hedges 1898, which rules that an innocent party cannot be forced to pay for partial work unless they had a free, genuine choice to accept or reject the incomplete structure. Moving on to the application of legal authorities directly to the facts of our scenario. On the first issue of the RM 9 million, the legal reality heavily favors Arman. The facts state that by August 2024, Arman had physically executed approximately 75% of the total construction works. Because a vast portion of the project was actually built, Emerald cannot argue that there was a total failure of consideration. Under the modern doctrine established in the case of Lim Swee Chu, partial performance completely blocks a total failure argument. Therefore, Emerald is legally barred from using Section 66 to force a clawback or refund of that RM 9 million, because that money strictly represents valid architect-certified stage work that Arman rightfully completed before the contract broke down. However, the legal tide turns completely against Arman when we analyze his claims for additional compensation or the outstanding RM 3 million balance. First, under the case of Carter against Powell, this lump sum construction contract is treated as an entire contract, meaning complete performance is a condition precedent to payment. Arman left 25% of the complex unbuilt, so he fails this rule. Under case of K.P. Kunchiraman, a contractor can only sue for the contract balance minus defects if the work is nearly complete. Abandoning a massive one-quarter of a commercial project due to financial insolvency does not satisfy this high threshold. Finally, Arman's quantum merit claim under Section 71 fails under the rule in the case of Sumter, because this incomplete three-story structure is permanently fixed to Emerald's land. Emerald has no genuine or free choice to accept or reject the partial work. They cannot simply walk away from their own land. Because there is no voluntary acceptance of the benefit, Arman cannot legally force Emerald to pay a single cent more for the incomplete work. In conclusion, Arman is legally entitled to fully retain the RM 9 million paid to him for his 75 partial performance, as protected by the Lim Swee Chu case and the case doctrine and Section 66 of Contracts Act 1950. However, he is completely and firmly barred from claiming any further compensation, quantum merit, or the outstanding contractual balance due to his own fundamental breach, financial default, and failure to meet the strict legal threshold of complete or substantial performance. In short, the law protects what Ayman has already earned and been certified for, but firmly denies him from any further financial recovery. With that, I conclude my part of our group presentation and thank you very much for your time and attention.